All right, let's jump right in. Today, we're tackling one of the biggest, most heated debates out there right now, the massive legal showdown between artists and artificial intelligence. You've seen the headlines, you've heard the arguments, and it all boils down to one really powerful question. When an AI makes a picture or a song, is that a brand new creation? Or is it just high-tech theft, like so many creators are claiming?
Okay, so let's break this down. On one side, you've got creators. They're saying, hey, my life's work, my art, my photos, my writing was just gobbled up to train these AI models, and I never gave permission or got a dime for it. But then on the other side, you have the AI companies, and they argue, whoa, hold on, our systems aren't just copying and pasting, they're learning. They're analyzing billions of data points to understand patterns and concepts, basically turning art into math, not making some giant collage of stolen work.
Now, when you hear all this, your first instinct, right? It's probably, well, this sounds like a job for copyright law. It's the tool we've been using for hundreds of years to protect creative stuff. It just feels like the obvious answer.
But here's where the whole story takes a fascinating twist. What if reaching for copyright law isn't just the wrong tool for the job? What if it's actually a dangerous trap that could end up hurting the very artists it's supposed to help?
So let's really unpack this idea, because it's a little counterintuitive. We need to look at what some legal experts are calling the copyright trap.
Legal scholar Karis J. Craig defines it like this. The copyright trap is this very tempting but mistaken belief that strengthening copyright is the best way to protect creators from AI. Her argument is that, while it looks good on the surface, it's a tool that's really likely to backfire, especially on the little guy, the independent artists.
So how do we get lured into this trap? Well, Craig points to three really common arguments. First, there's this gut feeling, the if value, then right fallacy. It's the idea that, hey, if a giant tech company is making billions, someone must have a property right they can claim. It just feels fair. Second is this blanket idea that copying is wrong, period. But that ignores the fact that copyright law has always allowed certain kinds of copying for things like research or learning. And third, and this is a powerful one, is the starving artist story. We use the very real struggles of artists to push for stronger copyright. But when you look at history, those stronger laws have almost always ended up helping massive corporations way more than individual creators.
And the stakes here are absolutely massive. As Craig says, this trap is most dangerous for the most vulnerable artists, the very people who are most drawn to its promise of protection. And once we go down that road, once we expand copyright to cover AI training, it could be nearly impossible to ever go back.
Okay, so this is the key question. Why? Why is copyright such a terrible fit? To get that, we have to look at how AI is fundamentally flipping the whole process of creativity completely on its head.
First, we gotta start with a bedrock principle in copyright law. It's called the idea-expression dichotomy. It sounds complicated, but it's actually pretty simple. Copyright law says you can't own a general idea, like, say, a painting of a sunset. But what you can own is your specific, unique expression of that idea. Your brushstrokes, your choice of colors, the composition, that's the part that's yours.
Now check this out, because this is where AI just turns everything upside down. Traditionally, a human has an idea, and then they do all the hard work of creating the expression. With AI, the human still provides the idea, but they do it as a text prompt, and the machine handles the expression. It generates all the brushstrokes and colors for you.
So this immediately brings up a huge question, right? If the AI is doing the expression part, then where is the human creativity in this whole new process, the part we're supposed to be protecting?
And the answer, according to experts like Mark Lemley, is that creativity itself is shifting. It's moving away from the final product and into the art of asking the right question, into becoming a master prompt engineer.
And that single shift, it has a massive consequence. It completely shatters the main legal tests we've used for decades to prove if someone actually copied your work.
This slide shows the problem perfectly. Before AI, if two paintings looked really similar, it was a pretty safe bet that one copied the other. But now, with AI, two different artists could just happen to write very similar prompts and get almost identical paintings from the AI. The final images look the same, but it proves absolutely nothing about whether one person copied the other person's creative act, which was the prompt. Our old legal test just falls apart.
And on top of all that, trying to draw some clean legal line between human work and AI work is basically impossible. It's not an on-off switch. AI is a whole spectrum. You can use it for one tiny thing, like mastering a song,
or for generating a baseline, or even to create an entire song from scratch. Where on earth would you even begin to draw the line for what gets a copyright?
So given all these deep, fundamental problems with copyright, you can imagine the entire world is kind of scrambling right now, just trying to find the right tool for this new job. Let's see how that's going.
And not surprisingly, the global approach is, well, it's a mess, a total patchwork. You've got the EU, and they're focused on transparency, making AI companies tell everyone what data they trained on. Then there's the UK, which was thinking about a big exception for data mining, but has now slammed on the brakes. And then you have Japan, which has gone in the complete opposite direction, saying it's pretty much okay to train AI on copyrighted stuff, even for profit. There's zero agreement on this.
Okay, so if copyright is a trap, and the world can't agree on anything, what are creators supposed to do? What other tools are actually out there?
Well, it turns out people are already getting creative with other parts of the law. Legal scholar Daryl Lim points out that they're finding other ways. You've got the right of publicity, being used to fight those creepy deepfake voices of famous singers. You've got trademark law, which Getty Images is using to sue AI companies for copying its watermark. And even simple things like the terms of service on a website are being used by the New York Times to legally block AI bots from scraping their content. These might just be better, more precise tools for fixing specific problems.
At the end of the day, what all of this really shows us is that this isn't just some nerdy legal debate for lawyers. We are smack in the middle of a much deeper, more fundamental conversation about the future of human creativity itself. What do we value in art, and what does that look like when machines can create it? Which really leaves us with this final massive question to chew on. Copyright was a tool built for a world of human authors. But as we speed into a world of human prompters, what new tool do we need to invent for that world?